Free trials and other attractive subscription deals lure in customers. But what if you change your mind? What are your rights when you sign up to these services, and what are the potential pitfalls? In this video, I'll reveal when a company can convert your free trial into an ongoing subscription, why you can't always cancel immediately afterwards, and the law that's on your side when it comes to subscription traps. I'm Daniel Barnett, a barrister practicing in London and presenter of the Legal Hour on LBC Radio. To stay up to date with these and all my other legal explainers, please do subscribe to my channel and click the notification bell. Thank you. Many free trials automatically convert to a paid subscription if you don't cancel by the end of the trial period. Now, this is legitimate, provided the terms of the contract you enter, usually by ticking a box online, make it clear you'll be billed if you don't cancel. But by signing up, you're taken to have agreed to the company's terms and conditions, even if you haven't read them. So it may often be a good idea to actually read what you're signing up to. Although some companies rely on customers forgetting to cancel, that's not against the law. The burden is on you to remember to cancel by the specified date. The company doesn't have to remind you that you're about to exit the trial period, so it's often worthwhile diarising a reminder for a day or two before your subscription auto-renews. I use a service called followupthen.com. It's completely free. Have a look on the internet. What if you cancel a service partway through a billing period? Do you have a right to a refund for the period you don't use? Again, this depends on the terms of the contract when you signed up to the service. In the entertainment field, many content providers effectively prevent you from cancelling the service before the end of a billing period. For instance, if the billing period runs from the 1st of March to the 1st of April and you want to cancel on the 14th of March, you'll generally have to pay for the full month of March, even if you cancel halfway through. Provided this is set out in the terms and conditions of the service, this is legitimate. But under section 62, subsection 1 of the Consumer Rights Act 2015, an unfair term of a consumer contract is not binding on the consumer. The Competition and Markets Authority say over lengthy notice periods may be unfair in a contract which lasts indefinitely. But a notice period of less than a month is unlikely to count as over lengthy, so it's unlikely you'll be able to insist on any refund. Some contracts do give you the right to cancel without a notice period, so it's worth checking the wording of your contract. Many food subscription services offer heavily discounted prices for a few weeks. Their terms and conditions make it clear the service will continue indefinitely unless cancelled. This is generally the case even if you don't select that week's meals. So if you want to exit the contract before the discount period ends, make sure you keep to the deadline. The company is entitled to insist on a hard deadline, so make sure you stick to it. You don't cancel a service by simply ceasing to pay for it. That's important. Just instructing your bank to cancel a direct debit isn't enough. Although this prevents the money from being taken out your account, it won't cancel your contract, and subscription-based companies may pursue you for the outstanding balance, and they're legally entitled to do so until you've formally notified them of cancellation. Notifying your bank is not enough. Always make sure you've cancelled either online or by phone. Keep a record of the date and who you spoke to, or by giving the company notice in writing by email that you're cancelling the contract. Free trials and discounted offers can often benefit consumers and suppliers, but some subscription services overstep the mark. Now, this problem led to a report by Citizens Advice, Locked In, which investigated the problem of subscription traps. This is where consumers are misled or inadvertently sign up to long contracts. It found some suppliers make cancelling a subscription deliberately difficult. For instance, they may insist cancellation takes place by phone or email, and then it's very difficult to get hold of them by phone. Most of those who responded to the Citizens Advice online survey had signed up to subscriptions without realising it. Nasty surprises and additional charges can be contained in the small print. Some of these might not be enforceable, no matter how much the company insists they are. The Consumer Contracts Information, Cancellation and Additional Charges Regulations 2013 require the companies to give you the following information before you buy online. The main characteristics of the goods and services, the total price or how it'll be calculated, all additional charges including delivery charges, the total monthly cost or cost per billing period, the duration of the contract or how to terminate it, and any minimum duration of the contract. This information has to be given in a clear and comprehensible manner. If you haven't been told the monthly cost or cost per billing period, if you haven't been told the delivery charges, if you haven't been told the return fees, you're not obliged to pay them. Making clear to the company that you understand your legal rights can often result in a refund or a quicker cancellation. I'm Barrister Daniel Barnett. You may like this video. Thank you so much for watching. Bye bye.